to Medina alone for 75 or 74 kilometers of road. As I was talking about Accra road.
The chairperson of the Electoral Commission, Mrs. Jane Aduko-Mensah, testify. And in our case, we wanted her to come in and testify as an adverse witness. Now, that is allowed under the rules, specifically Section 72 of the Evidence Act, allows a party whose interest is adverse to another party to call that party and treat that party as a hostile witness. Now, the strategy that we had adopted was basically to serve a subpoena on her, because as you recall, she had decided that she was not going to give testimony even after filing a witness statement. And we decided that we were going to call her by compelling her through a subpoena that would have been issued through the court system and served on her. But today, the Supreme Court gave a decision in which it basically said that Mrs. Jane Aduko-Mensah will not be compelled, to testify. In our view, the court was wrong. In our view, the reasons of the court were based upon wrong legal premises. But the Supreme Court is the final decision maker when it comes to the law. And we have no reason not. We are bound by what it has said, this morning. We cannot depart, from it. But lead counsel for the petitioner has indicated that he is filing an application for review with respect to the earlier decision rendered on the 11th of February relating to their decision with respect to the compellability of the witness testimony of the Electoral Commission. Now, ladies and gentlemen of the press, the Supreme Court asked itself a question which we deem was a wrong question and answered that question. It said, why does the chairperson need to account to the people of Ghana when she's not a party to the suit? Now, you recall that counsel made it very clear that one of the reasons why we are in court is because of the unconstitutional conduct of Mrs. Jane Aduko-Mensah as the returning officer under the Constitution. And it is not true that there is only one issue that needs to be determined in this matter. I am surprised that the Supreme Court itself, having set down 5 key issues to be determined, is now reducing the issues to one, which is whether and the extent to which the evidence that we have laid shows that no one got more than 50% of the votes in accordance with Article 63 of the Constitution. But we have made abundantly clear in the petition that there were a number of infractions. We are contesting even the constitutionality of the declaration that was made. We are saying that she violated Article 23 of the Constitution because she is an administrative body. We have also said her exercise of discretion was contrary to Article 296 of the Constitution. These are all germane issues under the Constitution and laws of Ghana. And to reduce the petition into a single issue petition is rather unfortunate and smacks of a predetermined agenda to rule against the petitioner in this matter. The Supreme Court was called upon this morning to exercise discretionary power, judicial discretionary power with respect to whether we should reopen our case. Now, in doing so, the court was bound by the provisions of Article 296 of the Constitution, and we think that the reasons, as I've said, that the court gave are not acceptable. They are not tenable. The reason is simply because you cannot expect that we should have made our evidence, the evidence that we're going to present to the court, available ex ante or before the fact, so that the court will now determine whether or not this is evidence that will help the case. In any case, the petition and other pleadings filed before the court makes it clear, and any trained lawyer will know that the pleadings show very clearly the evidence that would be laid in order to be able, to prove the facts in issue. And so for the court to say that we were bound by law to make our evidence available for it to assess before allowing us to reopen our case is a legally problematic proposition. And therefore we disagree with the court. We think that the court, by this decision, has not done the people of this country a great service, in the sense that Ghanaians are interested in knowing the truth. Our constitution is very clear that justice emanates from the people and must be exercised in the name of and for the welfare of the people. The justices today have not given us a reason to believe that they want the people of this country to know the truth about what happened, that they want the people of this country to be able to say why figures kept changing on the from the 9th of December till date. If you go to the website of the Electoral Commission, the figures have changed 5 times. Are we not worried as a nation that the returning officer appointed under the Constitution cannot even explain to us what happened? She made a declaration based upon a figure that she herself changed without recourse to the law. Is this something that we want public officers to be, engaging in? And secondly, she's a public officer. And as a public officer, she's accountable to the public. She's paid with taxpayers' money. Why is it that she cannot be called to testify? Why is she being treated as if she's a private person? Why is she being treated as, why does the court treat this important constitutional matter under Article 64 of the Constitution, something that could have been brought by an ordinary citizen of this country, as if it is a mere private matter, as if we are involved, as I said a few days ago, with a debt collection matter? This is not a debt collection matter. This is not a commercial litigation that we are engaging. And so we are highly disappointed with the decision of the court. Maybe the issues that we have raised today will feature in the review application that we have brought before the court.
The motion for stay.
And we are also filing a motion for stay of proceedings pending the hearing of our review application. So thank you very much if you have any questions.
Doc, at the risk of social media abuse, I have to ask, how much further, how much longer is your side going to go? For a number of applications now dismissed, the substance of the case itself, we haven't had a pronouncement on that yet, and so we cannot seek to say what would come out of it. But at these very press conferences, sometimes the comments that we get from your side suggest that you don't even believe in the ability of the court to determine or give an impartial judgment. I would reference a comment you just made that suggested that the ruling we had today was predetermined. How much further are you going to go?
Well, thank you very much. We are determined to go as far as the law allows us to go. And that is because we want the people of this country, the discerning citizens of this country, to see everything play out in the court, and that is the highest court of the land, and for us to be able to let everyone see that our resolve to pursue the truth is unrelenting. So we'll go to all the lengths allowed by law. As we have said, the Supreme Court has a review jurisdiction, and we are invoking that jurisdiction to take a second look at its own decision. And the review application will be filed with very solid legal arguments that we think should convince the court. If the court is not convinced, whatever options are left, we will pursue them. But we are doing this for the people of this country. His Excellency John Dramani Mahama brought this petition for the defense of the Constitution. He has a community of interest with the Constitution. And I want to make one thing abundantly clear. Sixtus, if you were the plaintiff in this matter, if you had sat in the comfort of your room and tallied all the figures, and if you were convinced that this matter, the declaration was in error, the Constitution allows you to bring an action. And your community of interest is with the Constitution, to defend the Constitution of this country. The judges have sworn an oath to defend the Constitution of this country. And so every constitutional issue that we think is germane and legitimate towards the resolution of this matter, we will raise until final judgment is given.
All right. Look, thank you very much. I stand corrected, but at the very heart of this petition is the fact that the petitioner claims that no candidate attained 50% plus of the total votes, valid votes, thank you. And the petitioner has come to court again, also asking the court to annul the results as were declared on the 9th.
Okay, yes, on the declaration.
On the declaration, yes. Okay. Now, my question is, so far, has the petitioner been able to prove that none of the candidates actually got more than 50%? If no, is it going to be through the cross-examination of the first respondents that will reveal that none of them had more than 50%? If no, then your case is dead now, is it?
Well, don't prejudge the case at the risk of being held for contempt. I would dare say that the case we have brought is very clear on the face of the petition. If you read the petition, it is very clear why we have brought this matter. Now, in respect of the figures, we made it abundantly clear from the beginning that these were figures compiled by and announced by the Electoral Commission. You remember that we wanted to inspect documents. Our request was not granted. You remember that we wanted her to answer interrogatories, which are allowed under Order 22 of the High Court Civil Procedure Rules. At first they said they were not applying CI 47, and subsequently they had to rely on CI 47 to save themselves. All right. They did not permit us to administer the interrogatories. These are all mechanisms allowed by law to elicit evidence. And I don't see why the petitioner in this case, or anybody filing a petition as a citizen of Ghana in this case, cannot obtain information from the person who conducted the election for purposes of proving that the declaration she made was unconstitutional because none of the candidates obtained more than 50% of the votes. And let me say this, you see, there is a tendency, and I think that is where we have all gotten it wrong. Okay? I gave the example of Sixtus, you know, as an ordinary citizen mounting this challenge. Could the court have asked Sixtus to go to all the 275 constituencies and bring pink sheets? But read Article 64, Clause 1 of the Constitution. It says any citizen of Ghana may bring an action. So you can rely on the evidence compiled by and announced by the chairperson. In fact, in any jurisdiction, having seen situations of multiple summary sheets coming from regions, having seen situations of pardon, vote pardon, and admission of vote pardon by the respondents themselves, the court itself would have ordered an inquiry into the extent of vote pardon. And that would have not been based on our figures, it would have been based on the figures compiled by the Electoral Commission. And by the way, no party goes into an election produces figures. The official figures are produced and announced by the Electoral Commission of the Republic of Ghana. Why is the Commission not throwing that evidence to all of us to say, look, here it is, this is what we did, now tell us why we were wrong? Why are they not doing that? And why is it that you as journalists are not asking that question of the Electoral Commission? You know, the notion that just because the principle of law is that, you know, he who alleges must prove, then it means that because the petitioner has come to court, he must produce the evidence by himself. Cross-examination is one way by which you can prove that burden. Why are they running away from cross-examination? Why are they running away from bringing evidence? And by the way, we filed a notice to admit facts. Okay? The law is that after 14 days, if you don't answer, if you don't admit, those facts are deemed in law to have been admitted. All right? So, in fairness to the petitioner, the facts enumerated, you know, for admission are deemed admitted. And let me say this. You see, they have decided they are not giving testimony. What is the legal consequence of that? It means that our petition and the evidence laid in proof of the petition stand unrebutted. That is the position of the law. And let anyone come and challenge me that that is not the position of the law. The court should have actually gone ahead to strike out their figures, I mean their witness statements and their pleadings. Why is the court not doing that? That is a legitimate question that the petitioner is entitled to ask.
Just a quick one on the quest for Madame Jean Mensah to be cross-examined, testify and be cross-examined. The court in today's ruling said that you had not proved the relevance of testimony. Doc, you are shaking your head. Indulge me when maybe. You had not proved the relevance of her testimony to your case. It's one of the many things that was said in the ruling. I don't have the benefit of a written text. I just had to listen to it.
Yes.
And you have demonstrated, again, at a lot of these encounters, that there's a critical part of this case that is hinged on Madame Jean Mensah's testimony and her cross-examination. And it seemed that is where we are now. She must enter the box at all costs, putting it, you know, in a layman's terms. Let's assume Jean Mensah falls sick or takes ill tomorrow and cannot. What will be the direction of your case?
The court will adjourn until she's well enough to testify. that is said on a lighter note. But I think you may be going down the route of saying that, look, we haven't produced sufficient evidence to be able to discharge our burden. We think we have, all right? And again, the legal consequence of not testifying will have to kick in, all right, at this point in time. And I think that it is important that we highlight the fact that they have decided they are running away from giving evidence. And as journalists, I think you should be asking them more critical, you know, questions than you are asking the petitioner. At the risk of being, you know, petty, I think you are being unfair to the petitioner. You journalists are being unfair to the petitioner. You are not asking them critical questions. I mean, you file a witness statement. You represent it to the entire world that you are coming to give evidence. Why run away?
Maybe.
And by the way, before you come in, let me say this. Before you come in, you have, you saw the video in which Mr. McMenu said that they could also prove that, there was pardon in favor of John Mahama. right? Is the court not interested in that? McMahon basically admitted that there was wrongdoing by the Electoral Commission, but the wrongdoing affected both parties. Is the court not interested in that? So that Jane Mensah could come and then say why she parted votes in favor of the petitioner and parted some in favor of the respondent. And then also let us see the extent to which the vote party helped one party or the other. Isn't that an important question that needs to be answered? And who best to answer the question than the person who declared the results?
Let me ask. Doc, just a quick follow-up. You made a point about the fact that, as it stands, your evidence has not been rebutted. Should that not be good news for you and allow for the case to proceed for a judgment to be delivered? And the second point, Doc, at the start of proceedings, we cited a letter that had been written asking for some additional arguments to be made. The court said it has noted that. Do you think that if you had the opportunity to perhaps address the court on that, it could have changed how things went? Then I realized that a larger chunk of your address this afternoon.
Now, Akable, you tend to ask double-barrel questions. Can I take them one after the other? All right. So, in the first, place, you are asking
about the evidence that you said.
Because
the evidence that you said has not been rebutted. So the first thing is, if it's not been rebutted, that should be good news for you. You should apply for them to strike out.
If you were interested in just legal technicalities, like the court, is applying legal technicalities at this point in time. We are not interested in just the legal technicalities. We are also in pursuit of the truth. That is why we think it is important that she should testify. All right. In addition to what we have, the evidence we've laid, we think that if she testifies, Ghanaians will see that we didn't just come to this court making vain allegations without proof. We have laid evidence, sufficient evidence to show that there was vote padding, sufficient evidence to show that there were, conflicting figures from, regions and constituencies and so on and so forth. All right. So we also made, it came out very clearly that the Form 13 that she said was a Form 13 wasn't a Form 13. Okay. And as I promised you yesterday that there will be very, salacious evidence coming out with respect to Form 13. And I told you that Form 13 is the reason why they are running away.
And Doc, is this evidence that was not available before you filed your case such that you could have put it through your own witnesses?
No. Okay, so, Form 13 was available to us. All right? But Form 13 wasn't put in our, we didn't put Form 13 in. Form 13 was put in the witness statement of the electoral, of the first respondent. Now, Akable, you do remember that there was an attempt to put that form into the evidence through Dr. Michael Pesa-White, and we resisted it. And then it was Justice Gertrude Tokunu who still pressed, and the form was shown to Pesa-White. And you heard what Pesa-White said. When he said it, the court went very quiet. All right? He said, this is not the Form 13. That the Form 13 as spelled out in CI 127 is different from this one. Was counsel, my good friend Mr. Justin Amenivo, not in court? Why didn't he protest? And why didn't he, get up to show to the court that the Form 13 that had presented was the same as the Form 13 in 127?
Doc, finally, I was asking about the letter and the fact that you were
the court, we thought that, if we cited those authorities, it will assist the court, okay, because it's a court of law and a court of justice. And therefore, the issue, you remember that the issue was raised very late at the proceedings yesterday, when Justice Mafusau basically said that there was a judicial bar, because Jane Mensah was not, she was a party to the proceedings. And we said, no, she's distinguishable from the Electoral Commission. All right? There was no time for us to be able to address the court sufficiently on the matter. But upon further research, we decided that we were going to cite these authorities to the court to assist the court in coming to a tenable legal conclusion. Unfortunately, the court took the letter, but decided to treat it with contempt.
So Doc, is it your contention that if the Supreme Court goes ahead based on the evidence that the petitioner has put forward to determine this matter without hearing from the respondents, it will be a miscarriage of justice?
No, can you ask the question again?
No, I'm asking that, are you saying from your arguments that if the Supreme Court goes ahead to determine this case, this petition that is before it, without hearing from the respondents, it will amount to miscarriage of justice?
Well, not necessarily, but justice demands that the truth be told. And that is why we are in pursuit of the truth.
All sides are fair.
Doc,
Okay.
Doc, you indicated that the truth demands that justice be told. In this
Justice
case,
be done.
Justice be done. In this case, it looks like justice for you is for the EC chair and the returning officer to answer some questions. It's so clear that it's not going to happen. There are people within your party.
Are you know the outcome of our review application?
So far, it's clear.
No, you know the outcome of the review application. Are you predicting?
So far, it's clear it's not going to happen.
I mean, you see,
and with your comments that you believe that some of these rulings have been predetermined, people within your party are asking you to withdraw this particular case. There are a number of people within your party who say, look, this thing will not end us anywhere. Just withdraw it. Would you do that?
You see, when it gets to a point in time that ordinary citizens, lay people, can predict court rulings, all right, I leave the justice or fairness of otherwise of the rulings to your judgment.
I think this should be the final question. Sun is very scotchy.
Okay. And your back court no, at some sea court no, akoye arehusem kakra. It's saying say, Jane Mensa or ye electoral commission ni dream trainer abatra 2 ina jina ne sono. Ye ba nese enka court man ho kwan. Nanko omegina dakanu na nsem bebre amanfo bisano watimi ya no ankoba ne sa court se oni ye nyadwen nti nanso biom akwakoye 70 a me no ukasei omo sei wo mo ma ho kwan magemensa emma adakanu na ne awo ho sem ne se ye mra ye adwuma ogana ha no eye evidence act no section 72 ma ho kwan se obi a woni no kura nyaadwe no kura wutumi fe no obeda no wadanse enne yamra no mom eda nchen enne yakofa ebrochie mu abibira be hihye mu a edi aka asem enne ne hunya pass obi abehu ni se yen as petitioners no ya dwumpo ina ni se ye bedi no kura na chia kosisi ensa beka no kura no ensa ensa se ye pe no kura hunu a Nukrani na se jemensa eba be gina de kanum na ne esi yankasa no waka esense sa wodwa nsem no bi e ka ya for example you say ye di abanu bi keka ho vote pardon aya makmenu o kasama na na ekufuad wa be gya tum se ayampa ye di abanu bi keka ho why na di abanu keka ho jemensa nkwa ne betime yi ano se wi enu nsu fi wa jemensa nkasa ba be ka kire ense why mistakes bebre e wo na asemu na denti na why mistakes na emebe gina de kanum na kire ye from 30 ya use form wa yedi e ka asem na ngata no why use form wa what yedi use anya no nso na we use ye uko use form foforo enti ye na me no kase ye wo results baku enum a ye nim results ko yedi edum ogana enti se sana tie na nia ogina mu oye abano yesi bra begina betuma na wo say unma why na betima be kirekiremu One a bit me about chance and some nation when they see when one a bit me. Now, one kakra says Supreme Court. Baby, a Supreme Court dinano. Nanka, I was say Supreme Court can say me na say accountability and far evidence in my. I don't want my judge to say mistakes. I dear McMahon on the say the idea no be kika. And at the intina, who can't see evidence evidence being done about Chelsea, yet I didn't be account. Evidence being a Chelsea, yet the young fan says go before for the grand and your Mahaman or Patricia, and Cassandra because of Congo resource Mrana. Your resource, you're the back court, a near or Minumra, a man who comes on for resource or no need Jim Mensa. What banners a problem we want, or no qua. Ni results na so ba bechiretim onu ni agina so se omra no nchire mu baako ayedai and mistakes ye hu na ye hu ye be say me che mo boss ye expectations ni de ye be die chire obi bisa say adenti na ye withdraw ni enkoto da bi ya amase ye be say wini nko o ye ba nso say Ghana fo na be hu no kura wa asemi mu esan say John Mahama odo no wa ba for say obi be hu no kura wa asemi na wo utifi a utie mi no wo hu ni say abatro na eto no kura enie e ba ni say mistake ba ha and a mistake am ba ha abale sa na nie ye ba court no ne yasaka ye nsa ba ye ba court na no kura grab ya eno ani ade epe no kura enti ne yo ha ye da mo say
But if there are more questions and people want to ask questions, they should have a right to ask the questions. We can't stop them from asking their questions. Colleagues, good afternoon. We want to start by reacting to a number of comments that have been made by the spokespersons for the petitioners' legal team, and then we will deal with our summary of what has happened. I'm sure you have all followed, and so we don't need to even spend so much time on that one. Our colleagues who speak for the petitioner started off by telling you this afternoon that they are of the view that the Supreme Court of the Republic of Ghana is wrong in law, at the ruling that it has delivered this morning. They also claim that the Supreme Court has reduced the petition to a single issue petition, and that smacks of a predetermined agenda. I'm sure you heard the words used by Dr. Ayine, that the Supreme Court has reduced the petition to a single issue petition, and that smacks of a predetermined agenda, ostensibly not to rule in favor of the petitioner. Now, we want to deal with those first two. While dealing with a third matter, they keep banding this word about truth. What is the truth? And that the truth must be allowed to come out. We'll deal with the question of truth as they talk about it. And then this claim that the Supreme Court is shielding the EC chair from getting into the box. In fact, in Chi, they make the argument that the Supreme Court doesn't want to allow the EC chair to give testimony. We'll deal with all of those before we come to our submissions. And then they make the argument that they are doing this for the people of Ghana and in the defense of the Constitution. We honestly don't think that is true. We'll deal with that one. First, let's deal with the issue of the court being wrong in law. This is the Supreme Court of the Republic of Ghana, a bench of 7 justices. And I think on about 2 occasions, 2 others have come to join them to review some of the applications before them. Except for the application for leave to amend the original petition, it is true that all the applications that have come before this court have fallen flat. But how can it be that the petitioner's communication team now argues that the 7 justices or the 9 justices are always wrong in law, and only Mr. Chachuchikata is the one who understands the law, knows the law, and is therefore always right? It cannot be. The last time they won some arguments that some of their paragraphs of Mr. Rojo Metununu's witness statement should not be struck out, you heard them right before you that it was a monumental victory Are those not the words that they used? And we keep making the point that it is not fair to the judicial system, it's not fair to our democracy, it's not fair to the people of Ghana that when you lose an application because it is not grounded in law or because you have failed to meet the legal standards, then you come here and literally poison the minds of the public and make claims that they may be having a predetermined agenda. That's scandalous of the courts. It's scandalous of the courts. When you make a legal argument and it is upheld, that one is good. When you make an argument and it doesn't meet the threshold, then it means that they are wrong in law or that they have a predetermined agenda. The Supreme Court has not reduced the petition to a single issue. We tried our best to transcribe the ruling. We are waiting for the written version of it. The court said that the major issue, it didn't say there was a single issue before it. It said the major issue. And time again, colleagues, we have read out to you the 5 issues that the court is seeking to determine. And the court says that the major one, and I believe in the minds of every well-meaning Ghanaian who has been following, and I indeed heard it from your questions, the major issue, you forget what they said earlier that they had won. The major issue they brought to court was that nobody had crossed the 50% threshold. And everybody's been looking forward to them adducing evidence to prove this. They have been trying in the last 1.5 weeks to shift it to a new constitutional accountability argument. And the court reminded us the last time that you came here under Article 64(1). The court today has said that the major issue, why do you then decide to mislead the public that the court has reduced the petition to a single issue petition? I think it is very unfortunate, and we must start off by correcting some of these issues. Now, they talk about the truth, and that the truth must come out. The truth must come out. What is the truth? The truth is what the EC chair has declared as at now, that Nana Addo Dankwa Akufo-Addo validly elected because he got more than 50% of valid votes cast. The truth is what is backed by the results of the 38,000 polling stations, or the 275 constituencies, or the 16 regions, which anytime we give them a calculator to calculate, they get 47% for Mr. John Dramani Mahama, 51.2% for Nana Addo Dankwa Akufo-Addo. That is the truth. If you come to court claiming that there is another truth, you have to lay it before the court. So where is the truth that you say you want to lay before the court? You remember when the court asked them, they said they had left their truth at home. They did not bring their truth to court. So which truth is the court supposed to look at? The presumption of regularity is before the court, and you say there's another truth. Where is it? And you say you won't bring it, and that the EC chair must be compelled to get into the box so that you can conduct some surgery and explore the truth out of her. We are not being fair to the people of Ghana if we continue to change the goalpost at every hearing. Now, they continue to make this argument that the Supreme Court is shielding the EC chair or preventing her from getting into the box. The court has said over and over again, and we hope that our colleagues on the other side will pay attention to what the court is saying. The court has said that you cannot compel her to get into the box. She will elect. Indeed, your own argument earlier was that she had elected to get into the box. And the court, after listening to the argument, showed that no election had taken place. So that argument falls flat on its face. Why do you now come and tell the people of Ghana that the Supreme Court is shielding her and preventing her from getting into the box? Because she is somebody or a party who you have brought to court. And the rules settled from the beginning that you cannot compel her. Whether you come by subpoena or you come by any other instrument, you cannot compel her. This argument, therefore, that the Supreme Court is shielding her is one that, again, our colleagues in the media, I think you have to be very quick to call out and let the public know is not true. That is not what has happened. They are the ones who objected to the closure of the case of the first respondent without putting her in the box. They objected. Why? Because they said she owes constitutional accountability. And the court has said that you haven't provided any authority or any law to show us that she should be treated with a different set of rules. Why do you misinterpret that to the public, that the court is shielding her? We think that these things should be called out. Now, there are 2 paragraphs in the affidavits that were before the court today that I want to read out to you. And I beg you to pay attention to this. This is the affidavit of Mr. John Dramani Mahama in support of the motion to reopen his case. Remember, we kept saying to you in the beginning that it was becoming obvious that they have not succeeded in making any case before the court. And that what they have put together before the court, 30 out of 35 paragraphs, are complaints about the declaration. It doesn't attack the validity of the election or the validity of the results whatsoever. And they said what we were saying was not correct. And we said, bring your witnesses to come and prove it. 3 witnesses they brought could not prove it. And when the Supreme Court heard them announce that they have closed their case, and the first respondent said, I will not get into the box to adduce any further evidence. Determine this matter on the evidence that they have brought before you. And we said same. They objected and said they wanted to bring her in. The court ruled on the 11th of February, the law does not support that position. Then they have come with an application to reopen their case. Now listen to paragraph 20 of that application, and that affidavit supporting the application. It says that this witness has a unique role under the Constitution in respect of the presidential election that took place in Ghana on the 7th of December 2020. And having her testify is critical to this court. What Mr. Mahama and his lawyers are telling the court, that they themselves don't believe that they have made a case before this court, and that if this EC chair is not compelled to get into the box, their case is collapsing. That is what they are admitting by paragraph 20 of their own affidavit, Mr. Mohammed's application, Mr. Mohammed's affidavit to support the application that they made. That if this witness does not get into the box, or if this person, this party, is not compelled, dragged into the box to testify for them, they have not succeeded. But if you've made a case, why are you begging the court, going up and down, misleading the public that if this person is not brought into the court, you cannot make a case? I thought they said initially they had won, or that nobody won, and that they had 5 witnesses who are going to prove it. They are now telling the court that if the court does not compel Jean Mensah to give evidence on their behalf, and yesterday you heard that they want to call her as their witness and they will treat her as an adverse witness. And by the way, the court explained today that that argument is not sustainable in law. It falls flat on its face. There's no legal position to back it. They are now saying that if she is not compelled, they can't make a case. Now, when yesterday the learned Akutuampao, in paragraph 12 of the affidavit supporting our position, said that the instant application does not raise any new matter of relevance which could not have been discovered by diligent effort and does not warrant the grant of leave to petitioner to reopen his case. They said this was irrelevant. And today you heard the court essentially going back to these arguments and the authorities that we had raised to come to a ruling that the position of the law is settled, that you cannot compel a party to get into the box to testify. So it is not about truth, some truth which you say you have left at home, and you are asking the court to drag the EC chair into the box so that you can conduct some surgery on her and find the truth out of her. It is about a legal argument of whether or not she can be compelled into the box to give evidence. And indeed, if you have some truth, why don't you lay it before the court? Now, colleagues, we heard you argue that, or we heard you question, that now some of their own supporters are saying that perhaps they should withdraw at this point. And indeed, it is our view that Dr. Ines skirted around the issue, didn't respond to the question. Says he leaves it to the judgment or the conscience of people. Why are NDC supporters now saying they should withdraw? Because they are observing before their very eyes, as this thing is televised live on TV, that their petitioner and their lawyers are not making a convincing case before the court. What they told them is not true. And that is why now they are asking the court to reopen their case so that they can put a party on the other side in the box and compel her to testify to make their case. It's becoming clear right before your very eyes that this is the reason for which their own supporters are telling them that it is about time that they abandon their case. But we want to conclude by dealing with this argument they make, that they are doing this for the people of Ghana, and they are doing this in defense of the Constitution. We vehemently disagree. What they are doing, this so-called petition before the court, is not for the people of Ghana or in defense of the Constitution. It is for the political interest of Mr. John Dramani Mahama who desires this media spectacle to sustain his brand equity and run again unopposed in the NDC in 2024. Let's be honest about it. It's not in defense of any constitution, because if it was, the constitution says that our legal system is adversarial, and therefore you can't compel a party in the box. Why would you be claiming you are defending the constitution and asking the Supreme Court to turn the constitution upside down? Those arguments don't hold the test of time. Today, the court has reaffirmed the decision it made on the 11th of February, that you cannot masquerade the same application in a different dress and expect it to do that which the law does not allow it to do. We'll take your questions.
Right. Honorable, good afternoon.
Good afternoon.
So, on several occasions, whilst addressing us, you have referred to the fact that the petitioner also appears to be panning towards public opinion and saying things out of court just to win public sympathy. Unless the second respondent doesn't believe that public opinion is important, I'd like to find out from you. First of all, there was an application for interrogatories. It was dismissed. In the public opinion, it was the fact that the EC, the second respondent, the first respondent, I beg your pardon, has something to hide. Then there was another application to allow the petitioner to inspect some documents. Again, your counsel opposed to that. What went out in the public domain was that there was something to hide, and that is why you were opposed to it. Now there's a refusal to present witnesses.
A refusal to compel.
Well, first of all, your side said you chose not to present the witnesses. Again, the opinion out there is that then it means there is something to hide. If there is nothing to hide, and if the public opinion is also that important, why don't you just open up?
Well, we have said over and over again that this is a court of law, not the court of public opinion. What our colleagues on the other side do is that they come to court and they make arguments that, according to the Supreme Court, these are not my words, according to the Supreme Court, are not backed by law. The Supreme Court has said on about 3 occasions that we don't know any law that supports what you are telling us. In fact, 2 days ago, they asked that this application you have brought, what's the legal basis? So we are praying to the inherent jurisdiction of the Supreme Court. There are times when they cite cases, early stomach law, the court says it doesn't apply. Several times they end up speaking at length, and the court says that the law doesn't support the grammar you are speaking. These are not my words. It's the position of the court. Then they come here and they spin the story to create a different public opinion, that the interrogatories are not being up. And you heard Dr. Ayine repeatedly say that the interrogatories were not allowed because the court claimed that CI 47 doesn't apply. We challenge him. The court never said that. Get a copy of the certified ruling and read it. The court has never said CI 47 doesn't apply. The Supreme Court holds all the powers of the courts beneath up to the Supreme Court and has been using CI 47. CI 99 applies to the procedure in here, but some of the basic powers in CI 47 or as amended 87, etc., they all apply. And the Supreme Court, in using CI 47, said to allow interrogatories, they must be relevant. The question is a question of relevancy. If you come and you ask irrelevant questions painted as interrogatories, the court will not say that just because interrogatories are allowed, it should grant you those when the questions hidden in that box are irrelevant. And you heard His Lordship the Chief Justice said that this your application falls flat on the grounds of relevancy. So if you come and you poison the public mind that they didn't allow it because they have something to hide, you are not talking law, you are talking propaganda. If you come and you say, if they have nothing to hide, why are they not allowing us to inspect the documents? You are not talking law, you are talking propaganda. Because to be granted leave to inspect, you must meet a certain legal... But why don't you want to meet the legal standards? Why don't you want to make a convincing legal argument? Do research, back it with authorities. You heard us yesterday, quote authority upon authority, Poku versus Poku, Berima, all of these ones quoted. Today you heard the court even adducing some of those to back it. You don't want to come with arguments and legal basis and with propaganda arguments to the public. Why do you want to tell the public that somebody can be compelled? When indeed that's not the position of the law. These are not my words. This is what the Supreme Court is saying. So the court of public opinion matters. But you, our colleagues in the media, we won't fight with you. We won't say you are not being fair to us or argue with you like that. In fact, we apologize on their behalf to you for what they did. But you have a responsibility to help educate the Ghanaian public that what the people are saying is not law, it's grammar and propaganda. Because there are legal standards that must be met. And the court has been, in fact, today, let me just go on one small tangent. If you notice, the court for the first time set out the parameters for determining when you can grant leave to reopen case at the Supreme Court. Any impact on results, obtainable by due diligence, the materiality question, importance of integrity of the process, prejudice, miscarriage of justice. They have laid down about 4 or 5 principles today before you and I this afternoon. This is law, not grammar. So when courts below are now looking at this matter, this is what they will apply to. We pray you to also take an opportunity to help us educate the public so that people don't go telling them stories. Because if that was the case, we have hinted you twice or thrice that, listen, if an argument can be made for a party to be compelled, i.e. the EC can be compelled, then it means that John Mahama can be compelled. Not so. So we should stop the legal work and now make an argument that, okay, we are come to compel John Mahama, we are come to compel John Mahama. We provoke thinking by throwing some of these things out. But just to answer your question, the Court of Public Opinion matters, but you have to help us to educate the public so that people don't throw propaganda out there. Yes, sir.
What does it hurt, whether in law or in the Court of Public Opinion, if the returning officer for the December 2020 presidential election, Madam Jean Mensah, takes the stand? Again, the clear what direction the court is going to go on Thursday. So question is whether you are still going ahead to file your addresses or you are waiting on the new processes that we have just been notified of to see how that goes.
Sixties, I'll deal with the second one first and I'll come to the first question. So you heard at the end of the proceedings today, Mr. Chikata announced that they will be applying for 2 reviews. The review of the February 11 decision and the review of this decision as delivered. And that they have filed, initially that's what he said, they have filed in the last, he said in the last 20 minutes or half hour. And the bench asked, have you filed or you are filing? And then later he changed, he said, we're in the process of filing. I believe it should have been filed by now. Indeed, for those of you who are in court, when the bench sat and started reading out the decision of the court, then one of their lawyers with the documents got out, even before the ruling was completed. You saw it in court. And you can tell your viewers and listeners whether what I'm saying is true or not. Stepped out to go and start filing the process.
We saw somebody walk out of the court. We don't know where the person went.
He's the one who went to file it. It's a matter of public record. But here's the point. The exchanges between the bench and the bar was to the effect that, so what happens to the submission of addresses on Thursday? And His Lordship, the Chief Justice, says that our orders still stand. So those orders we understand that we should respect. And he said that if the court is seized with it and the registrar has given a date for it to be heard before then, this court will come back and hear it. And we'll be here also to make our views known on that. Your first question was about what does it hurt? It turns the Constitution of Ghana upside down. It turns the adversarial system of law, which is in our Constitution, upside down. It compromises the time-tested, laid down procedure for adjudication in our courts, which is that when you allege, you prove. That when you tell the court that you have closed your case, you must have some extraordinary circumstances to demonstrate to the court before it will grant leave for it to be reopened. When you don't do that, you don't come, excuse my point, with the propaganda argument of, oh, but what does it hurt? It hurts the Constitution, it hurts the law, it hurts justice. We are here for justice. We are here defending every single vote that the 13 million people cast. Those who voted for Nana Akufo-Addo and those who voted against Nana Akufo-Addo. We are defending all of those votes. If you say that those numbers are not correct, why don't you want to take the responsibility to come to the court and say, these are the numbers that show that this one is not correct? And you say that it is critical to compel the Mensah to get into the box so that you can make him the case. Or you can make your case. In 2013, Dr. Afarijan entered the box, not because he was compelled by subpoena. Dr. Afarijan entered the box because the brilliance of Alhaji Dr. Mahmoud Baumia in demonstrating 11,000 pink sheets and the problems with it compelled Dr. Afarijan that if he did not get into the box, the job that he had done was going to be set aside. There's a major difference between these two cases.
So you've given us a duty to go and educate the public that this is a court of law and not, for grammar. Now, the ruling of the court today would mean to say somebody who just voted, a first-time voter, that the chairperson has, answered questions on behalf of the commission. And
Sorry, I can't hear you. Well, you're saying that the ruling of the court today is
yes, it suggests to say that once Madame Jean Mensah answered in the response, then it means that the commission has answered. So the understanding they are going to get is that Jean Mensah is the electoral commission.
Go ahead, I'm listening.
And so in that case, how then do I go and convince somebody who just voted for the first time that this is the court is not shielding the chairperson of the electoral commission, but rather is making sure that the vote they cast is protected?
Because somebody came to court with an application that the numbers or the declaration that I hereby declare that Nana Danko Akufo-Addo was validly elected and is therefore president-elect. Somebody came to court saying that declaration is not correct. That person is refusing to give evidence to prove it. He's brought 3 witnesses, and now he's saying that his witnesses didn't do a good enough job. And until they drag the EC box into the chair, he can't make his case. And the court is saying that flies against the Constitution, it flies against the adversarial system, it flies against the system of law we practice in this country. It has nothing to do with the EC chair answering questions. If you want the EC chair to answer questions, we can invite her to Parliament. There's a whole constitutional provision for parliamentary inquiry. But the forum that you have chosen and the constitutional provision you have invoked, Article 64(1), is not the platform for general constitutional accountability. Are there any questions, my colleagues? Thank you very much.
Abusanfo ni adehia anemwo ha yebeda mo ase enenso eyeda etoso edunsia yehia ewo ha na ansa na no mesre sene da ya ne mu ye adwuma no efe adwuma nsentrofo mo ye ne eye enti mi nso magina afidie so na mapa macho ye nuanum NDC fo omu nsam e na omu kasa tietia mo ne ntoko omu ne mo ko mu bisa asema na akwese abufuo na nsam omu kana kwa kasa twitwe ne mesre ye ne ma na ye adwuma yi enti no mamo mfa eye hwansena ho ahi na mo kwabre mu kuro ya pa chawa ma yenuanum NDC fo mo kasa na munye hwam na munye kra na yesai atwa so biema ene asema ye ba wo hase no ehu behia opani Dr. Ayene Mr. kasa eno be kasa ye e kam yakwa se ye ka ne gu eye Supreme Court mpanifo ehu fi no enye ehu ye pa sanse what the wasam eba Supreme Court gidia owo nyina ne se ahwene ti won pani animu a ebi nyira edisa what the wasam ba pani anim pani ni ka asam na asa ba abonten na wo de kasa twetwe kasa emunye de kasa huntie na wo de ba na wo kasa nokura Ghana fo peso mu hunu eye mpanifo yi a mo Supreme Court yi epese omo kasa eye kasa enye kasa ebu court animtia enti Dr. Ayene mesre baby obi am se wotia on pacho enye kasa eye kwa na wo sa ka biem se ene Supreme Court nsem o mo kan ye no so no emba pepepe yo atentene o masini trase na mra no o mo afa na mo du mra ni komu a eye kasa enye papa na biem mo san kasa enye Supreme Court mpanifo yi omu asan ehye eye Madam Jean Mensah chi ena mo kanisie ena ase omu pese obekasa enye kasa efe kra abusu asanka ye kan bi panke nei osanka dwumadi a ye di wo Supreme Court onfa na nibre so nanka onfa no se eya asemu ehu hia sempo yesi opani Mahama court oba ye Obama Ghana fo enso ye hia court dem a empredunsia emu mienu pe no aba emu du nan no omaye nanso no ono yenka se ana yenka bibia mfentia no asambe na aba abusuafo asama aba ne se Ghana ha ye mra ne kire wa obokwa edu no ona ade ho adansidie ba ye Evidence Act section 1417 ekire ana wo konso anya adansidie keke adansidie mu oduo It is a court now bone crow ye, who can was some ye. Not why would the 2 court and him say? Once some more wakan when yajin ye pa into Wasam, what bone crow ye, what to pum. Na court to so the nano asama to so. Na court nano asam to so we are not and if one so a respondent no almost the omano asamaba. Na way a dance for a mofra in some more can court in Yano. Na insisi so, na enyinam raso, na nyan someone a was a year and if one almost say on my dad yet. And uti and someone court a kind say. Same poor person with your homa, I saw a mammy Jane Mensacon. Now Bejna Dakum. Now dear Dancia, I'm running Chessa. Ye nim Ranswa, ye did me Massam, and ye did wasam, and I'm Rafu Francois, ye did mammy Jane Mensasam, I'm running a bacupe. Nagana have Nebian who have been to be so much that no one dance. And the Wako for Dino and Punechi, and I was Abba say, who case her. One casa would do one, and you've been a kind. What close to case? Now see what you are growing area, what won't crave you know. What's I say, court in my kind be was 7. Now the quantity will be was something to say. What per se court, Eddie and share, as some Madame de Mensa no Bejana that come not to Tunano. Court Nasa more can say. Answer now baby as some money no. Maybe I could have danced the beer dancing in a brand would be some near young yet. And yan on qua, and pokra dancing yedo. Na I was at with Trim say, I am Payana Washe. No one ya break, so we have dancing now on Sanka. Now fade on Saka. And yan on qua, I was at dancing near dancing dear more do. Ah, a bit to me as such a ya some na ye dinner. Debbie, where the some of the bar cotton and ya dance dear Fufrubia. Name as some more cannes ye me as many. Now Muntimis and Madame de Mensa and Bambijana a year courting. And on a quarter cassa and Brano and Chessa. Nanya do bit me a nempo. And Rayajina Hayasaka assemble could say. Justice Oleno can send me say, or be Albacco Tabejina Obiasam so. So would any pan and becan asem, and Sana was some way you do no, not send the Paronebia would trim a cow. And Yamina Makaye, a year of Penage and Phoebe versus Bedu. And a beam Poku versus Poku, and also a Supreme Court Asamoa. Say, and you'll be your quadrufour. Wa won't pay Juma. Wa wono. Ramundo was to cause any Amrane cano. Name a mobile court when you ha. Now, Obanano or say court no more. There be court and yadia court besa. And to court and was a mouth the bayano. And they say, Emrabian, one of my best shep, my midget, Mensa, so maybe not a come. Near 1370 can say, Papa Payonti, Sa Semun with the Hunti, Kamami J. Mensa, or Bananco Bijana Kamana Yade. A busham for and Sama or Bapa J. Mensa also can you know. Oko abe from Fidie so easy ewo ho ne nkrata ode abakot ewo ho ade kronti amami je mensa wan nyina da kamuni se ye nuanom NDC fo ne petitioner no o mentimi amfa dance a eka forma from pai amakot in fact en someone be kan court nyina no e ma ye yasama ye kan kra no ahyemu kina ye yasama ye kan kra ma mo edu enti in someone ye kan nyina ne se omuni asem mo be kaya ne edi kan amane sen sam no kra no nka court ni kan mongu na court said there be the beka ansem a eye botaya enu ntie ba ha se no ne ye diafra enti ye kra ne edi kan ato nkradada samo nsem a mo de ba court no emu ha emu nyedu enti abusua enen nsem ekosi ye no ne nyina agina mra so na ye ba court a sabi enye enkurobo ne ye ba bebo ena nya agudie ne ye ba bedi eye mra enti na ye ba ha sei ade bia ye wo ha bia no eye mra enti ne wo ha o ba fa dance bra me mana se mreyo e wo wasem a wo pese wo gina obi so na de ye wo wasem da bi eno enya ade a court ebe pene ama sa asem no akoso abusuafo nyame ya adom a okina anase na de chie ye besa ahia na wo hwe ensem a court ebo ne tofa ne nyina na ne omo kan nyina ne se enya ade a court ebetimi ama kwan ama Madam J. Mensa ababegina ho na central for busa asem bi na emuye me de pa sanse NDC for bi e kase omo withdraw omo case and withdraw omo case no kra NDC for kasa omo dika because wunya witness no betra da kam no kase krata ode ne sasha ase no aye opani rojo metonunu krata na mfumso no ye na EC chair ne dada no wo se EC chair esake no epamo no enso na adanse aba be dadi se ukonum tea na biscuit ni amfa amawo ne nyinaa no yɛ nneɛma a ɛbɛda adi enti NDC for common for serious opani Kwasa White busa na usi nipa oba bedi dwumadi kese sei usi ufri fiaba no ura fi charger wo fie enti phone bedum ye enti nipa wo pay figures na fi no ho constituency regional level no nipa ne person ofra wa enkomo be no betimi wadi enti ye nuanu NDC for common paba e wa asem ni mu eno nti no na omo ka tro mo nkofo se asem na be kra nka mo free court because mo am nkofo mbedi adanse kra no adanse di ombedi ye no emu eha opani esiedu nkatia obetra da kamiama ne bu nkontana ne nkontana kwakosi se na nado danko akufo adunya ohamu nchichemu aduonu ne ekirei enkota bi obu ye bia ekire saa enti esiden enene musa ba ebeka kire se agi se mumu case ni nyenti no mo de ahye mo krata mu se ehu be hia pa ma mumu case se na be mu case mbe edu agi se ma meje mensa ba bigina da kam ebusuafo ye nuanom NDC for any petitioners no omasem na nkasa no omadwen mu omato agu enso bi eni agina mu nyame ya adom a ye beba court biem court a chese obi amfa ne closing addresses aye ya wie no obi amfa na asem ngu krata so ne ensan emfamra nyame nhyira mo NDC case ne de atonsuom na sania dam ya no mesre mo chairman Makmenu aka ye nchen e wa ase aka ye ho star witness on ejin mo mampani na nado danko akufado ya mame lawyer Joyce Opoku Boateng so ha sei lawyer Faisal e wo ha lawyer Lennon enso e wo ha eye Hajia Fatimatu Abubakar eye lawyer papa ono so wo ha minister in charge of information designate ono amu nso SI eye lawyer Evans Nimakon ono in charge of elections ono nkuntabu e course ba nya no ono na di animu lawyer Kiamu a me say lawyer so
the thickness of the asphalt, is very minimal, and it will reduce the cost. So when we talk about costing of roads, you don't take it, at its face value, because 1 kilometer of road, even if it's for surface dressing, could be 5 times or 10 times more than the same length of road elsewhere because of the ground conditions. That determines the cost of the road. So in road construction, you can say that a kilometer of road being brought to surface dressing level, bituminous level, is, let me use tentative figures for the sake of argument, 1 million. So if you hear that the same kilometer of road somewhere is 3-4 million, is outrageous. It's not, because at that second place, the conditions might be different. There might be bridges, the ground soil might not be the right, well, it has to be taken off, covers, and so it depends upon the ground conditions. So don't take it that because I said it costs 1.5, every asphalt kilometer would be that much. But on the average, because it's just an overlay, simple overlay, it could cost that. But depending upon the area, it could be higher. That's the point I'm making.
Okay. Mr. Ajari first, then I'll come to you.
Okay. Before the MP, honorable nominee here, before the MPP came to power in 2017, The NDC had already awarded a number of road contracts, and the contractors were at the various stages of construction. I have the Volivo Bridge in mind. I have the Ward K Town Roads in Tamale in mind. I have the Tordom Town Roads in mind. I have the Mesedan Boyem Roads in mind. The MPP wrote formally to these contractors to stop work. 4 years down the line, nothing has been heard. And this is common throughout the country. What are you going to do if you are giving the nod in terms of all these roads that have contracts and are still lying idle? Thank you.
I thank you, Mr. Chairman. Mr. Chairman, so far as my memory serves me and goes, it was only in the area of Cocoa Roads that some projects were halted for review of the contracts and decision to repackage some of them and to manage the road sector very well. I'm sure it became very necessary because if you may recall, there were a lot of contracts awarded between June and December 2016 under what was termed at that time as enhanced projects. In fact, a number of them, as I was informed, because it was being handled by Cocoa Board, the procurement processes had even not been completed, and they had to halt them to review them. At the end of the exercise, a number of them were resumed, and contractors were asked to go back and work. Others were repackaged and re-awarded. As we speak now, so far as I am concerned, majority, if not all, and perhaps it may not be all, but majority of them, work resumed and are going on. With Volivo Bridge, it's a different facility. It's being done through JICA. It's through a Japanese facility. The facility is available, it's ready, and Honorable Abrapa is here, and it is in his constituency, and it's one project that he has been following on closely with me. The facility is there, but we needed to do the approaches, the roads, because if you don't do the approaches and build all the roads, that facility will at the end be a white elephant. So JICA and the Japanese government was insisting that that should be done by the government of Ghana, and they have made money available for the bridge itself. Fortunately, I am happy to announce that that amount has been obtained now, and Greek Development, African Development Bank, is financing that project. And within this first quarter, if I am eventually approved, is one of the projects that you see light of day within this first quarter. And Honorable Abrapa knows it. Thank you, Mr. Chairman.
This is a quick follow-up before my last question. Still on those roads that have been abandoned, you did not mention Mesedan Boyem Road. It was awarded and work has started in earnest, and a letter was written to the contractor to stop work. It is one of those roads that the government never got back to the contractor to either tell him to go on or off. And for your information, that has been a den for armed robbers. Just last week, a young man was shot 3 times on that road because of its deplorable nature. What do you say to that?
Yeah, thank you, Honorable. Thank you, Mr. Chairman. This is a very important information. If eventually I am approved, I promise that I will work closely with the Honorable Member to resolve this issue. I thank you, Mr. Chairman.
Chairman, which issue we wanted for the record? I can pronounce those town names, but if Minister, she can repeat it. Okay, Chairman wants to do it, then we get Minister.
Mr. Chairman, the
Chairman do
road
for the record.
Honorable Member is talking about.
Mr. Damboyam, is that right? Does it start from Osui? And Osui, Mr. Damboyam, yes.
Minister, what will you do about Mercedes Boy Road, as I heard from Chairman and the Honorable Ejari? Thank you.
All right. So then my last, as the technical advisor to the President on roads, how are you going to ensure that government commits good amount of money to the road sector to ensure that our deplorable roads are fixed, especially those from the rural communities where we get both our cash and food crops like Techiman Law?
I thank you, Mr. Chairman. Government prioritizes road construction. There is no doubt about that. And it's the first time in the history of this country that a government has declared a particular year as Year of Road. It tells you, obviously, the importance government attaches to it. And it's essentially the President has even again at his latest State of the Nation address declared 2021 as Year of Roads. So, Mr. Chairman, I want to assure this committee that, and the nation, that government is going to work on roads, because roads are important in the scheme of transportation. Because if you take all forms of transportation, the road network constitutes almost 95 to 98%. So it's important. And the economic development of this country revolves around roads. Roads can open up the country and continue to serve as the pivot, around which all the good things and progress of this country revolve. So government will continue to invest in road infrastructure, and this government and the President have already amply demonstrated that. That's why within the past 4 years, there has been so much work in the road sector, even though we still have to do more. I thank you, Mr. Chairman.
Yes,
thank you, Mr. Speaker. Honorable nominee, we are very much aware about the Chuchuliga Sandema Wiesi Road, which was awarded on contract as far back as May 2016. In fact, I've had occasion to ask you questions in respect of this very subject in the House, and you give us very refreshing answers that the contractor was going to continue with works and finish on schedule. Originally, when the contract was awarded, works were supposed to complete by February 2019. But as we speak, we have not done up to half, 50% of works. My point is, what has accounted for the delay in the completion of the Chuchuluga, Sandema, Wesi road. It has great economic potential. In fact, the Wesi valleys, Fumbisi valleys, where rice cultivation takes place, is affected largely because of the bad nature of this road.
Thank you, Mr. Chairman. Mr. Chairman, it's true. In Upper East region, there are two main, very important roads there. I'm not by any way suggesting that other roads are not important. Any road anywhere is important, but in terms of prioritization. And one is this Sandima Road, which, as you said, leads to Fumbisi because of the potential agricultural expectation from that valley. As I speak with you now, even though there had been some delay, because we had to re-engineer that road, we had to do some repackaging. There is a contractor working on it now. It's my turn. It's your area, so you know it, working on that road. We have to speed up and to award other stretches of the road up to Fumbisi. And it may interest you to know that during this second term of President Akufo-Addo's government, the Agri Ministry is being challenged to develop the Fumbisi potential in terms of agriculture. I have already started discussion with my colleague, the former minister and the minister designate for agriculture, Honorable Dr. Akuto, to draw a program to ensure that the road from Sandima up to Fumbisi Valley is well developed to promote the expected work to be done in the Fumbisi area. And the Ministry of Agriculture is bringing in special equipment and machinery for rice production. So I can assure you that we are going to speed up work there. The other important road in the region, was the Boga-Boku-Pomakro road, covering a distance of 109 kilometers. And it had also been, one particular road that touches the heart of Honorable Ayariga. And anytime he speaks to me on that road, he is so appreciative of the work being done by government.
Just put money into it and do it for them, please. Yes, your next question. Yes.
Honorable nominee, there have been several complaints from some road contractors with regards to delayed payments relative to certificates raised for that purpose. Now, some of them have actually lamented that it appears that the mode of payment, selection for payments, is in a way discriminatory. I would come to that. Now, I have looked at your handing over notes closely, and I don't know which of the documents is this, but the one I have on page 11, handing over notes, Ministry of Roads and Highways, Volume 4, Ghana Road Fund Secretariat, November 2020, at page 11. Now I see a table numbered 5.3, outstanding indebtedness. If you look at the table, the total outstanding indebtedness as at September 2020 is 3,134,107,797.81 pesos. Out of this figure, payments amounting to the tune of 826,752,674.84 pesos was made, even though the total amount of claims, actual outstanding payment requests, was in the region of 1,826,959,604.55 pesos. So, point is, what criteria did you use to effect the payments to this tune, leaving the outstanding balance I have alluded to? I have said that for the past 3 years, they have forwarded certificates for payments which remains outstanding.
Thank you, Mr. Chairman. Mr. Chairman, I have already indicated in my earlier submission about payment, and I will not sit down here and say that payment in the rural sector and perhaps for other areas had been the best, even though government from its dwindled and meager resources, had done the best for the rural sector. For the past 3 to 4 years, government cumulatively had paid contractors to the tune of almost 10 billion. And the figures are there, the statistics are there. There are still outstanding amounts to be paid. We take the road fund, and road fund continues to have challenges. From 2017, this government has not had the full use of that fund. And you and I know, and everybody knows, because this fund was mortgaged as far back as October, November 2016 for a loan from UBA Bank at an interest rate of 32%. So the fund has not been wholly available to government, even though a lot of things had happened. For instance, we had to even refinance that loan because the amount that was taken was 1.3 billion, the entire annual accrual into the fund. We had to refinance it to Fidelity Bank and GCB Bank, like Ghana Commercial Bank, and we were able to bring the interest rate from 32% to 21% with 12 months moratorium. So we have been having these challenges, and we are not out of the woods yet. So we find money to pay contractors, we will continue to pay contractors, and I believe that going forward, work in this area will be much, much easier. And let me also say that perhaps in preparing the handing over notes, all the certificates there had to be captured. It does not necessarily mean that all of them are attracting interest because it's contractual that payment should be paid within 90 days. So that amount, because the handing over notes had to be at the close of the year, even if a certificate came in the last day, it will be captured. But it does not mean that government is paying interest on the entire outstanding amount. But one thing is true, and I am the first person to admit it, because I work with the contractors of this country, even though government has been doing its best. Government appreciates that more has to be done. And going forward, I know there are plans, which I can't share here, but there are plans, and the President is determined, and I know what I'm talking about, to clear all this within the shortest possible time. It's okay.
Yes, Honorable, is it Sweeney or Blackwell? Which one first?
Any of them.
All right, Sweeney.
Okay, thank you very much, Mr. Chairman. Mr. Chairman, I want to quickly draw the attention of the nominee that the communication from His Excellency the President and the rendition of his name as he provides on his CV, the Honorable Kwasi Amoako Atta, you don't seem to have my attention. Your Atta, is it with an H or without an H? The President communicates to us without an H. You have an H at the end. Which one is correct for our records, the accuracy of our records?
Thank you, Honorable Chair. Mine ends with H, so it's correct.
Okay, I hope the presidency will take note. Just very quickly, the $55 million looming judgment debt. The Honorable Minister responsible for national security appeared before us last week on the 10th. And when I posed this question to him about the looming judgment debt, at the time, we had not received the notice from the International Arbitration Court. Now we know that the Chinese company is suing Ghana for what they call wrongful termination, and we will be paying, if they succeed, $55 million. The National Security Minister told us that the Accra Intelligent Traffic Management Project was already being carried out by his ministry, and there was no need for your ministry to initiate that contract in 2018 and sign with this, sign a fresh contract with this Chinese company called Beiji Everywhere Traffic and Lighting Technical Company Limited. Is that an assertion you stand by? Do you confirm what the National Security Minister told the committee?
Honorable, are you asking him to confirm what the Minister for Energy told?
Yes, I want to know if that is the accurate account, the true position of this particular situation.
Honorable Minister, are you able to confirm or deny what had happened at this committee?
I thank you, Mr. Chairman. Mr. Chairman, it's true that notice of arbitration has been issued and my ministry has been served. And because of that, Mr. Chairman, if you permit me, since that legal step has been taken, I am stopped, and I do not want to comment on it until, the petitioners, go through and the matter is determined. But I will perhaps add that when my colleague, Honorable Minister for national security appeared, he made mention of an existing project, which is an Alpha project. It was true, except that the Alpha project was a specific project that dealt with CCTV cameras, and you know that project started from the previous administration, and the concentration was in Accra, Kumasi, and the 2 airports. So, if you like, I wouldn't say he was wrong, but he presented a skewed picture because he concentrated on cameras. But the Accra Intelligent Traffic Management Project is not only for the CCTV cameras. It's a project that had dual objective: to improve transport infrastructure and to ease congestion. That's all that I will say for now, and I wouldn't want to go into the merits, the details, you know, because of the fact that it is in my knowledge that notice of arbitration has been duly issued and duly served on my ministry. At the right time, the Attorney General of Ghana, if eventually is approved, you know, will obviously be seized with the facts, and that outfit, being the government chief legal advisor as per Article 88 of 1992 Constitution, will be the appropriate authority to deal with the matter. I thank you, Mr.
Chairman, Honorable Amoako, Chairman, just indulge me one more. My understanding, as the Honorable Amoako is seeking to know from you, I appreciate that you don't want to go into detail, but our understanding is that in Parliament, your ministry, as supervising ministry for roads and highways, came to Parliament for a parliamentary resolution to get this contract supervised by your ministry with a dedicated Chinese entity. Now, you also have the Minister for National Security come to Parliament seeking to set aside what you had done with a different Chinese entity seeking to do that work, which is what is occasioning the judgment debt. So, which ministry is supervising this or will supervise this, given the current information available to us as Parliament? Thank you, Chair.
And Chairman, better still, who terminated the contract?
Mr. Chairman, thank you very much. Mr. Chairman, as I have already indicated, these are all part of the reasons that gave the petitioners the course of action, and they have taken that action. Like I said, I am stopped, and I prefer that I don't comment on it now, and let the legal processes, you know, taken by the petitioners be carried out.
Mr. Chairman, my second question. Last month, specifically on the 14th of January 2021, the Ghana Chamber of Construction Industry issued a statement in which they assert that your ministry owes them 1.8 billion Ghana cedis in debt, and that after listening to the President at the inauguration declaring a second year of roads, they are doubtful that that will be successful if you do not pay them this sum of 1.8 billion Ghana cedis. Is this figure accurate, and what are your plans in redeeming this quite a staggering amount of 1.8 billion Ghana cedis to the industry?
Thank you, Mr. Chairman. Mr. Chairman, I have indicated a number of times that, yes, government owes contractors. The figure cannot be wrong. And His Excellency, the President, is not unaware of indebtedness towards contractors who work for this country. And the year of roads will mean using the same contractors to work. So government is determined to make all these outstanding debts good within the shortest possible time in order to empower contractors to work. And a number of contractors have done a lot of work. They have done yeoman's job. This country, salutes them, and government is working hard and will continue to work hard, to pay all these outstandings, so that we will be in a position to empower them, to use them, as we go ahead. Well, the declaration of 2021 as year of roads will require that we use these same contractors to work, and government is determined to do that. And there are plans towards the payment of all the outstanding debts. Thank you, sir.
So finally, by way of follow-up, we have discussed earlier the financing arrangement for all of these abandoned road projects, outstanding commitments, and all of that. I hold a different view, with all due respect, that it will appear that your ministry spreads itself thin and that you start so many projects at the same time. And that is why we always have these constraints. That it seems as though you succumb to the political pressure. Yes, I know the CDD-AFO barometer, for example, the round 8 they released recently, reveals that majority of Ghanaians, the number one issue is roads, infrastructure, how to get it fixed. And it appears the politicians are just succumbing to pressure. You award contracts even when you are not sure of a dedicated funding source. And so you have all of these projects littered all over the country without any guarantee that it will be completed in time. Don't you think that it is time to adopt a different paradigm? Finish projects that you start before you move on to start new ones or initiate new projects, regardless of the political pressure.
Yeah, thank you, Mr. Chairman. Mr. Chairman, it's a very, very, very important point. It has always been the policy of government and my ministry to relate all projects to be executed to a dedicated funding source, because the two must not be a mismatch, otherwise you create a problem. But at times in awarding contracts, the expectation is there. You know where the funding is going to come from, particularly if it's a GOG project, as we are talking about. The contract is awarded, and something which was not in contemplation at the time of the award happens. Unforeseen circumstances. And the classic example is the COVID pandemic. And we are politicians, we are members of parliament, and we are honest people, whether MPP, NDC, CPP, whichever government has been in power, the national pace so significantly. So it throws all government expenditure reduce revenue. That's why we have suffered some of this.
Thank you, Honourable Minister.
So I will add that even as far back as September, to come to my ministry issued. All regional directors and engineers. Last year, we have a world of new contracts. Necessary emergency, and unless it's an emergency, so that we will be able to deal with outstanding payments. And as we go forward, we are waiting for and
thank you, Honorable Minister. We'll come to you on the file. Yeah.
Right. Thank you, Mr. Chairman. Can the Security Minister there in this traffic matter, and so are not entitled to the of Ghana must be rest assured?
Honorable, I beg you, that is the matter that will be determined by the tribunal. If it were the court of Ghana, I would say he will be, what is the word? Assistant lawyer. So let that matter be determined by the court, please.
No, Chairman, I agree with your ruling, but just if I were to clarify what Honorable Suhene means, when the Minister for National Security appeared, he was told that some invoice had been prepared for work done by the contractor under the Ministry of Roads. I'm sure my colleague is just seeking to know, to confirm whether work was actually done under his ministry.
Honorable Leader, if I knew at the time what I know now, that the matter is before a tribunal, I would have disallowed that question. So I didn't know then. Very well. So please, let's leave that one.
I'm guided. Thank you, Mr. Chairman and Leader. Thank you. Honorable Amoako made reference to the situation that he thinks the ministry is spreading. So I have been through spreading itself thin. And going through this very good work, performance audit report collected roadworks in Ghana. So one is on underpass, then the pipe and gas. I see on page summary of projects. Canal some 14 million in 1.46 Ghana cedis. $125,000. That's the East Legon Spintex Road Tunnel project. And there's also a road project supposed to have 30 months, 47. The initial contract 358. I mean, on 30th June, 177,000. we ended the and 70,000. Minister, when you started, you spoke how contractors are paid based on first come, first served, depending on when their IPCs are submitted. Just at that time, I got text messages from contractors, Amoako, AS, Pebu, and Tascalia, indicating that their certificates have been with your ministry since 2015. And we all know how many contractors have complained about works that have not been paid for. Honorable nominee, generally, we know that some of these people may have been affected by whatever process and procedures that you use. Now, interest and delayed payments, as I have indicated in these reports, and sometimes inadequate road designs, have been seen to be a big drain on our resources, perhaps making it impossible for us to even do more roads as we require. So it may not just be about spreading ourselves thin, it may not just be about lack of resources, it is just because we spend so much paying interest on delayed payments, which leads to high costs of doing roads in this country. You have been Minister of Roads for the last 3 years. Now, what reasons, for the last 4 years, what reasons will you assign for these delays that lead to this interest payment that are a drain on our economy? And what have you done in the last 4 years to improve the situation?
Thank you, Mr. Chairman. Mr. Chairman, the observation by the honorable colleague is correct, that it's not in the interest of the nation to delay payment because of the huge interest accrual that come in. As much as the situation may be unavoidable, we must try as much as possible to reduce it. And one reason for doing that is what I have already said a short while ago, that all of us, and particularly the ministry, will have to be extra prudent in award of contract, so that we always relate it to funding source. And I'm saying we should be extra prudent in the sense that there could be unforeseen eventualities. So if we base the award on the expectation of funding, expectation of government revenue, and anything happens that we have suffered in recent months or last year, it creates a problem. So I agree with you that we are taking a second look of that, because it's not healthy, when contractors' payments delay and attract more interest. The contractors themselves are not happy, and they are not fond of the interest. No, every contractor...
So those are the systems you have put in place in the last 4 years to improve the situation, is my question.
Every contractor prefers that he's paid on schedule, he's paid on time. So
kindly help us.
What we are
can you listen, please? Kindly help us. The question he's asking is systems you put in place. It's about cash flow. do you have control over cash flow for paying for your contractors?
Chairman, that's why I have laid the foundation and said that we don't have control over the cash flow. Anytime we award contract, we do it on sound basis. But something happens and we are not able to meet the target. That's what we say, that we have learned from it. That's why we are now going gingerly in award of contract, so that we avoid delay payments and we avoid interest payments. That's the only choice.
Thank you. Yes, Honorable, please.
All right. Honorable nominee, the Bimbula Salaga Road, the Bolga Boku Road, the Salaga Mang Kango Road, the Tamale Nantong Karga Road, the third ring road in Tamale that passed through Kambli 4 and Taha, were all roads that were on contract before you assumed office as minister in 2017. Did you renegotiate these roads? And can you give this committee, can you kindly let this committee know the contract sums then and the contract sums now and the state of these roads as we speak?
Thank you, Mr. Chairman. Mr. Chairman, just some of these roads, like you said, were on contract, particularly Boga, Boko, Paumakro Road, was being undertaken by Quares, Davao. There were problems. At that time, work was not going on. Makango Road and all work had stopped. Before that time, we had made great efforts to get contractors back on this road, And if you take the Boga, Boko, Paumakro Road, for instance, covering a distance of 109 or so kilometers, I believe all being well by the end of second quarter this year, that road will be fully completed and then commissioned. What we have gone very far is about, if my memory serves me right, it's about almost 90–95% complete. Particularly the Boga Boku one, substantially done. They are now working on Boku Paumakro Road, and work is going on, and the contractor on that road, Quares Davao, is an efficient contractor. So it's going on, and all this. So we have done some negotiation with them, so that they will come about the road, practical rules, that work will go on. I cannot just on top of you figures and what it is now, but all that I can say is that these roads, almost the critical roads, the critical roads that second, third, and of roads, all are good.
Minister, your chairman, your assurance, Nanton, Karaga, Gushogu, and the roads mentioned by Honorable Soyine, what are your plans to get those roads completed? Thank you.
Mr. Chairman, we shall follow them up for supervision, bring it to that to make sure that we get the appropriate funding to finish this road. Work in earnest. In fact, we've been with greater this to live in our country.